jurisdiction to seek appropriate municipal law. Petitions dismissed.
The repetition, Annex 2 is.
There's no proof, sir.
I have approached you earlier.
There has to be, I don't know, just explain to.
There is no proof of delivery of that representation. You must file a press application.
I only page number 10, my let's see. I have that is mentioned. I have no proof that I have already mentioned the private opposite party number. My that name has already mentioned in private opposite. Even notice will or my
No.
Item number 2.
May I please, Your Lordship. This matter also similar to item 1. Here, representation to the opposite party number 4 at page 18, Your Lordship, on Annex 3, which has been duly received. The received stamp is there on the foot of that representation.
All right.
That is more than 1 year back. He has given this representation. 19. So
December 2021.
Let him give a fresh representation. That is better because this is a representation of December 2021.
So, all right. The petitioner's representation, Annex 4, be examined.
Annex 3, Your Lordship.
All right. Annex 3 be examined by the Tahsildar
Pallada.
And after notice the petitioner and opposite parties 5 to 9 and giving them a hearing. The reasoned order shall be passed not later than 1st August and be communicated to the parties within a week thereafter.
Item number 3.
May it please, Your Lordship. My Lord, in item number 3, the petitioners are there before Your Lordship with a prayer that the matter appears to be a perennial problem. We are all land oustees in Kanpur irrigation project in the district of Keonjhar. Your Lordship may kindly see the declaration I have given regarding filing of cases. That is at page 4. My prayer is very limited, Your Lordship. That will put an end to all the disputes for all the time to arise. Page 4, Your Lordship may kindly see I have given reference of around 20-30 case numbers, those which are still pending. Now, when Your Lordship, the project was taken up and our land have been taken up, we are declared oustees, displaced persons. We are entitled to rehabilitation resettlement policy. The benefits were not given. Now they have started filing writ petitions and various orders were passed. Contempt petitions were filed. Direction for representations were given. Now this process, Your Lordship, is continuing. My Lord may kindly see, recently an order passed by this Honorable Court in a group of batch of cases, around 20-30 cases, Your Lordship. Close.
How is this a PIL?
My Lord.
How is this a PIL?
Your Lordship, we are not making any prayer for ourselves, Your Lordship.
Who's we?
We are also land oustees, my Lord.
So it is their personal benefit.
Yeah.
They want to enforce their personal right.
Numbered it as PIL and you've brought it to the division bench. This is not a PIL matter at all.
My Lord, Your Lordship may consider my prayer I have made. Even I am the land oustee, other persons are there. Unless Your Lordship, there is a commission with Your Lordship's direction, the government.
This is not a PIL. First of all, this is not a PIL. You want benefit for both the petitioners.
Not only for
And
the petitioners,
but it was also
all the
by
and each case will
another
have to be
bench.
individually examined.
Land.
The minute you do all this collective thing, it will fail.
My Lord, I am filing, Your Lordship may kindly see, this reference, I have also referred the judgment of Honorable Supreme Court, very similar matter.
Sir, no problem as far as Supreme Court judgments are concerned. In your individual cases, you will cite it and whichever court has to consider, will consider it.
Your
And
Lordship,
has also been considered by the Honorable Justice.
What you are doing is very conveniently right on top when you're typing, you're saying writ petition, bracket PIL. So registries how can the registry know whether it's PIL or not? Because you have declared it to be a PIL. So registry is also placing it as a PIL. This is not a PIL.
my Lord, with respect, Your Lordship, I have also stated the reason why I have filed a PIL. Because of these it is continuing, your lordship.
It's not PIL,
My
sir.
lord, my lord, I bow down, your lordship. Your lordship, may kindly,
You want to
I-
keep multiplying litigation like this. This is the problem.
these cases, your lordship, were pending. I am not petitioner in any of those cases.
Maybe, but even you are equally affected.
I am equally affected,
Ah.
but large number
Now
of
suddenly you have woken up. Your two petitioners have woken up. You will have to face questions about limitation, delay, latches. So very conveniently, you are now projecting it as PIL.
no, my lord. My prayer before your lordship is that.
This is all ingenious way of somehow keeping the issue alive.
With respect to your lordship, these petitioners, they have no other interest except seeking a direction.
It's all about coming to the court in
Yes,
right
your
time.
lordship. My-
Otherwise, one ground which everybody has, petitioners are poor. Where will the petitioners go? Your colleagues every day ask me this question: where will the petitioners go? Petitioners are poor. So if these are the only two grounds, then there's no need for case law, nothing, sir.
My lord, I'll file an IA for the conversion of the nomenclature.
No. This is first of all not a PIL at all.
Yes, your lordship. I'll file an IA for conversion of the nomenclature.
No.
Because your lordship, we are the read petition has already been filed. I'll file an IA tomorrow.
No, 1 minute. This is not a public interest litigation. Since the petitioners are seeking relief for themselves, full stop. The registry will renumber this
My lord.
as a writ petition. This in the cause list, it's shown as simply as writ petition civil order, not PIL. No. See the cause list. No, but the number itself is just writ petition civil. The registry will therefore not treat, they don't say renumber, will not treat this as a PIL and place it before the appropriate bench
My lord.
on 1st May.
Obliged, your lordship.
Item number 4.
My lord, on behalf of Mr. Mahapatra, my lord. My lord, I have supplied a copy similar, passed copy of the order passed in a similar case, my lord. Where the petitioner was given liberty to file a fresh representation. In the present case also, the petitioner was, appellant was given liberty to fresh.
Same.
make.
All right.
Item 21 and 22.
Yes, my lord, similar 21 and 22, I
All right.
obliged.
Item number 5.
Item 5, outsourcing 8th August.
All right.
Item number 6.
Item number 6, your lordship has dismissed similar matters that UGC demonstrators. Given that copies.
I give it a copy, madam. Lordship's order.
That has been confirmed before on the apex.
Demonstrators claiming UGC.
All right. Same order.
Item number 7.
May I please, your lordships? Here, my lord, the appellant challenges the impugn order passed by the Honorable Single Judge under Annexure 8, my lord, dismissing the writ petition solely on the ground of delay, my lord. Wherein, my lord, the appellant had challenged the appellant had filed one petition under Section 15B of OSS Act, my lord, before the respondent number 1, my lord. The respondent number 1, without going into the merit of the case, dismissed the revision petition. Thereafter, the petitioner filed the writ petition. But your lordships may kindly see the finding of the Honorable Single Judge, my lord, at para 5. That is at a running page, my lord, 44, para 5 start. In the circumstance, this court finds there is no infirmity in rejecting the 15B application also on the ground of delay. Mr. Sahu, learned counsel for the petition, here attempted to bring into account the other grounds available for the purpose. This court observes, once the main proceeding suffers on the account of delay latches, there is no room for considering other grounds, even if there is availability of such grounds.
So what is the explanation?
Admittedly, my lord, the petitioner was a government employee and she was serving as a teacher in Gopalpur on sea, my lord. That I had also filed a limitation petition, my lord, which was filed
27 years delay.
27 years, yes, my lord. So 27, admittedly, there is a delay of 27 years. It was not within the knowledge of the appellant.
What
And your lordships may kindly
is
see.
not within the knowledge?
Your lordships may kindly see, my lord. I had filed the limitation petition that is also I have filed, my lord. That is at page, my lord, 31 of your lordship. Page 31, para 2, my lord. Page 31. That the petitioner, being a government employee working as a teacher at Gopalpur on sea, is always residing away from the suit land, and as such, she could not able to know the settlement operation convent in the locality where the suit land is situated, and hence she could not produce the relevant documents before the authority concerned for mutating the same in her favor.
Yes.
It's a land, my lord, which was purchased by the applicant's grandfathers-in-law, my lord. In 1946, my lord, I have filed the register cited under Annexure 1, my lord. Thereafter, the land was partitioned between the 3 sons of father-in-law of the applicant, my lord. I have filed that also. Registered partition deed. There is registered sale deed. There is registered partition deed, my lord. In spite of that,
your own revision petition, sir. It's not somebody else's revision petition.
my lord.
He was the
How can you not be aware of what happened in your own revision petition?
She herself
No.
was the
petitioner.
It was in the name of the applicant's husband, my lord.
No,
But
no.
applicant, yes, my lord.
Come to, if you have the writ petition,
Yes, ma'am.
you actually come to Annexure 4 of your writ appeal only. SRP 659 of 2007, correct?
Yes.
Who's the petitioner?
I am the petitioner,
Then what is your, not your husband, sir? You're the petitioner.
my lord.
Your own petition, how can you say you're not aware?
And it was on contest. She filed the written
On contest.
confirmation.
Correct.
My lord, this finding of the Honorable Single Judge is completely contrary to the judgment rendered by Honorable Apex Court in my lord Tukaram Kana Joshi, my lord. I am placing that judgment, my lord.
All right.
Para 12 to para 15, my lord. I have to place 3 para. Is regarding continuation of delay on para 12, my lord. No hard and fast rule can be laid down as to when the High Court should refuse to exercise its jurisdiction in favor of a party who moves it after considerable delay and is otherwise guilty of largesse. Discretion must be exercised judiciously and reasonably. In the event that claim made by the applicant is legally sustainable, delay should be condoned. In other words, where circumstances justifying the conduct exist, the illegality which is manifest cannot be sustained on the sole ground of largesse. When substantial justice and technical considerations are pitted against each other, the cause of substantial justice deserves to be preferred. For the other side cannot claim to have a vested right in the injustice being done. Because of a non-deliberate delay, the court should not harm innocent parties if their rights have in fact emerged by delay on the part of the petitioners. So and so. Then para, my lord, 15. Depriving the appellants of their immovable property was a clear violation of
Come to
Article
para 14. You'll know why the court is saying all that.
Para 14, yes, my lord.
Ah.
The High Court committed an error in holding the appellants non-suited on the ground of delay and non-availability of records. As the court failed to appreciate that the appellants had been pursuing their case persistently, accepting their claim, the statutory authorities had even initiated the acquisition proceeding in 1981, which subsequently lapsed for want of further action on the part of those authorities. The claimants are illiterate and inarticulate persons who have been deprived of their fundamental rights by the state without it resorting to any procedure prescribed by law, without the court realizing that the enrichment of a welfare state or of its instrumentalist at the cost of poor farmers is not permissible.
So are you following this category? Are you following in this category?
I am the teacher, my lord. I am the teacher. Admittedly, I am the teacher, my lord.
So you do not want to claim that you're illiterate?
No, my lord.
You're not inarticulate?
No, my lord.
You're not a poor farmer?
No, my lord.
Then?
But this
See, there will be always case law, but you have to see what is the facts
My lord.
which is persuading a court.
And in another case, my lord, this honorable court, my lord, condoned the delay of 19 years, my lord.
What are the facts there, sir? I can show you cases where they've even condoned delay of 30 years.
My lord.
Ah.
In Tukaram, that is 25 years.
There are cases of 30 years.
My lord.
No facts. We don't have to discuss any facts. Supreme Court condoned 30 years. Here it is 27 years. So condoned. Is that how we are supposed to follow case law?
But where there is other matters should have been gone into, my lord.
No. What is the explanation for the delay? Is it a reasonable explanation? Are we bound to accept any explanation, every explanation?
Because he was serving
now,
as teacher, that is the explanation to delay.
Limitation for writ petitions to 30 years, according to you. So, irrespective of facts, every petition where the writ petitioner comes to the court after 30 years, up to 30 years, you can condone because Supreme Court condoned.
No, man. Because she had given the ground.
See the section 5 petition. In section 5 petition, page 31, the only ground is that I am
not aware. I'm staying outside the property, so I'm not aware. That's all.
And this is the only land which was of the upland, my lord. Except this land, there is no land, my lord. And another fact is that, my lord, the municipality on whose favor the land has been recorded, my lord, they are given the holding tax also, my lord.
All right.
And her house is situated on this particular land, my lord.
All right.
There is registered cell deed, there is partition deed, my lord.
All right.
And the partition deed was amongst 3 sons of the father-in-law of the appellant, my lord. One of the sons had sold it to one Srimant, my lord. Those grounds were not taken into consideration by the Honorable Single Judge, my lord. May I play, my lord? Another date, my lord. I pray, my lord. Because it is the only source of what's shelter, my lord. Another date, my lord. This is the first.
Very surprised that a person like you is arguing like this.
My lord.
So you just decide when the court is not with you, ask for an adjournment, right?
Because I have a case, my lord. I have a good case.
Sorry?
I have a case, my lord. I can develop it, my lord.
You have what?
I have a good case, my lord. The appellant has a good case, my lord.
Develop it.
And another date, my lord.
Why should we give an adjournment, sir?
Adjournment.
Even your adjournment is not reasonable. As it is, your ground for delay is not reasonable. Now your adjournment request is also not reasonable.
My lord, I pray, my lord. And next week, then we date, my lord.
Sorry, sir. Sorry.
Then tomorrow, my lord.
No.
Tomorrow.
No. See, the challenge before the learned single judge in the writ petition by the appellant was to an order passed by the Joint Commissioner Settlement and Consolidation, Barampu, dismissing her revision petition being SRP number 659 of 2007 under section 15 bracket small b of the Orissa Survey and Settlement Act 1958. Strangely, revision petition questioned an order passed by the Tahsildar Rampu date of the order, that's not good. No, that's the date of the application. That would be passed 27 years earlier. Whereby the record of right, like the ROR, in respect of the land in question, recorded it in favor of the Berhampur municipality. Full stop. In seeking to explain the delay in approaching the Joint Commissioner, the appellant filed an application to Section 5 of the Limitation Act, where it para 2 is stated as under, take from page 31 of the writ appeal. In its reply to the SRP 659 of 2007, the Berhampur municipality pointed out that the appellant had not challenged the ROR by filing any case in any civil court or the settlement court, although 30 years had elapsed from the date of final publication of the ROR. Paragraph. In an order dated 17/8/2010 dismissing the above revision petition SRP number 659 of 2007, the Joint Commissioner noted that even on merits, the appellant failed to make out a case and failed to place documents to establish her title to the property in question. Paragraph. The writ petition challenging the above order was filed only on 3rd February 2013. That is nearly 3 years after the order was passed. In the entire writ petition, no explanation was offered for the delay in filing the writ petition. Therefore, there was delay at both stages, that is at the stage of filing the revision petition and again at the stage of filing the writ petition. Full stop. Paragraph. The learned single judge has in the impugned order dated 13 January 2023 noted that with the initial proceedings itself being barred by limitation. Continuation of delay of almost 3 decades would amount to unsettling a settled position. The learned single judge therefore declined to examine the other grounds urged by the appellant to assail the order of the Joint Commissioner. Paragraph. Mr. Sahul, learned counsel appearing for the appellant, referred to the decision of the Supreme Court in Tukaram Kana Joshi versus MIDC. Just find citation. To urge that the High Court must exercise its discretion judiciously and reasonably, and open quotation, in the event that the claim made by the applicant is legally sustainable, delay should be condoned. Unquote.
Pardon, my lord. Another judgment I am referring to. Another judgment, my lord.
This judgment of
Judgment.
He also relied on the decision of the learned single judge of this court and Bhagwan Jena versus State of Orissa, 103 2007 CLT 803. Paragraph. As far as the decision in Tukaram Kana Joshi Supra is concerned, it arose under land acquisition proceedings, where, as noted by the Supreme Court in para 14 of the decision, that the appellants there, open quotation, had been pursuing their case persistently, unquote, and were, open quotation, illiterate and inarticulate persons. Unquote, full stop. Noting that the appellants there were, single quotes, poor farmers. Unquote. The Supreme Court further noted that they belonged, open quotation, to a class which did not have any other vocation or any business calling to fall back upon, for the purpose of earning their livelihood, full stop, unquote. In the present case, the appellant does not fall under any of the above categories. Full stop. She has been a teacher in a government school and was in fact not living on the property in question and was not earning from it in any manner whatsoever. Full stop. It is her own revision petition which she had filed 27 years after the ROR had been changed to reflect the ownership of the Berhampur municipality over the land in question. Full stop. The delay offered by her, the explanation offered by her for the extraordinary delay of 27 years, as noted above, can hardly be said to be convincing. Paragraph. The court also notes from the order passed by the Joint Commissioner dismissing SRP number 659 of 2007 that even on merits the appellant failed to make out any case for questioning the ROR, since there were no documents to substantiate such a claim. paragraph. As far as the decision in Bhagwan Jena is concerned, there, the learned single judge of this court noted that the commissioner was, open quotation, already convinced and has noted in the impugn order that the claim of the petitioners has merit, full stop, unquote. And in those circumstances was of the view that the delay of 19 years should not come in the way of the petitioners in that case pursuing their remedy. Full stop. In the present case, however, as already noted, the appellant failed to make out the case even on merits before the joint commissioner. Paragraph. In the circumstances, the court is not satisfied that any ground has been made out for interference with the impugn order of the single judge. The writ appeal is dismissed.
Item number 8.
May I please your lordship? In this here, the judgment of the Lord and single judge has been assailed under Annexure 3 Miller, thereby holding that since the recommendation made by the Transport Commissioner to fill up the post of Assistant RTO prior to coming into the new rules, and that was rejected, and this Honorable Court has directed to consider the representation of the petitioner prior to coming into effect the new rules. So the petitioner cannot be debarred from getting promotion in view of the executive instruction dated 17/11/2081. Lordship may kindly straightway come to paragraph 28 of the judgment. Paragraph 28 of the judgment. But at page 53, Miller.
Yes.
In court, may I read, Miller?
Yes.
In course of argument, Lord and Standing Counsel appearing for the opposite parties took a plea that a new rule 2021 has been notified on 3/1/2022, Miller. Therefore, in view of the provisions contained in the new rule, the post of ARTO are to be filled up directly through a combined recruitment test. While considering such submission of the Lord and Standing Counsel appearing for the opposite parties, this court observed that the rule was notified and came into force with effect from 3/1/2022. And further, it was observed that the impugned order was passed on 11/10/2021 under Annexure 9, which is much prior to new rule came into force. As such, while rejecting the representation of the petitioner, the opposite party number 1 would not have taken resort to the and rightly he has not discussed the new rule 2021 which came into force with effect from 3/1/2022. Moreover, the recommendation under Annexure 7 was much prior to the new rule came into force, and the present writ petition was filed on 11/11/2021. Since the impugned rejection order has been passed prior to new rule came into force, the petitioner cannot debate to get benefit of promotion under executive instruction dated 17/11/1981 on the basis of recommendation under Annexure 7, merely because a new rule has come into force. Moreover, this court has to confine this adjudication to the law applicable when the impugned order was passed, and the present writ application is to be adjudicated on the factual background that was existing at the time of passing of the impugned order by the opposite party number 1 pursuant to direction of this Honorable Court in earlier writ petition. Lord, this finding is, Lord, clear against the law declared by the Honorable Supreme Court in case of state of Himachal Pradesh and Lord Rajkumar. Lordship. And my lord, the recommendation is to hold DPC for selection of post of ARTO. My lord, pending my lord, finalization of the draft rules that executive instruction govern the field. Lordship, kindly. This
Come to para 36, sir.
My lord, paragraph 36.
You please read it. You have permission to read it. Yes.
That a review of 15 cases that have distinguished Rangia would demonstrate that this court has been consistently carving out exceptions to the broad proposition formulated in Rangia. The findings in these judgments that have a direct bearing on the proposition formulated by Rangia are as under. There is no rule of universal application that vacancies must be necessarily filled on the basis of the law which existed on the date when they arose. Rangia's case must be understood in the context of the rules involved therein. It is now a settled proposition of law that a candidate has a right to be considered in the light of existed rules, which implies the rule in force. As on the date of consideration takes place, the right to be considered for promotion occurs the date of
Counsel the appellant places reliance on the judgment of the Supreme Court. It says there's no citation here. Dated 20th May 2020, not reported yet.
But not reported.
Not correct, sir. You're not looked up. That's all. Don't say it's not reported. 20th May 2022 in Civil Appeal number 9746 of 2011, bracket State of Himachal Pradesh versus Rajkumar, to urge that the earlier rule, which was explained in Y.V. Rangaya versus J. Srinivas Rao, 1983, 3 SEC 284, that vacancies that arose prior to the amendment of a rule have to be governed by the old rules and not the amended rules, has now been overruled by the Supreme Court. And therefore, the impugned judgment of this London single judge holding to the contrary is not sustainable in law. It's a notice returnable.
My lord,
10th
my lord,
August.
here, my lord,
There should be stay of the impugned
my
order.
lord, my lord, I am
He accepts notice.
my lord, I am appearing for the opposite party number 1.
All right.
If
The
your
other
lordship,
note, you just say notice to the other respondents.
my lord, may I be permitted to make one line submission?
There's only one respondent, all right.
My lord, may I be permitted to make one line submission?
But if you're ready, then we can hear it today itself. And
no, my lord, I am not ready because my power is not there. I have seen it. Your lordship kindly
no,
check.
but if you still want to make a submission, then we have to hear your submission. Then we have to deal with it. If you want to take your time, you take your
Yes,
time.
ma'am.
All right.
Your lordship.
Item number 9.
Your Lordship, on behalf of Amanan Saktipal, praying to withdraw the matter with liberty to file fresh representation.
Right. Disposed of withdrawn with liberty to file a fresh petition.
Obliged.
Item number 10.
May it please your lordship. The short grievance of the petitioner with the society is that, my lords, the opposite part number 5 and 6 are encroaching the approach road. Therefore, my lords, the society, the petitioner society has filed an application under Annexure 2 series before the Tahsildar and the collector that may be directed to be considered as per law, my lords. Opposite part number 5 and 6 specifically, I have averred they have made construction in the approach road. Therefore, the
petitioner's representations be examined by the Tahsildar, Sadar Katak, and after notice to the petitioner and opposite parties 5 and 6, and after giving them a hearing. The reasoned order shall be passed not later than 1st August and be communicated to the parties within a week thereafter.
I'm grateful.
Item number 11.
May I please, my lord? Your lordship may kindly see the order dated, last order dated 9/11/2020.
Interested in arguing your case or you're not?
My lord, I filed the case, my lord.
How many
Not
cases are you going to file? You already filed a writ petition earlier. Annexure 5. Come to Annexure 5, sir.
The application has been disposed of.
No, but you can't go on
Has been
filing like
disposed
this.
of.
So the same
Then I
cause
have
of action,
filed contempt
how many cases are you going to file? On the same cause of action?
My lord, in the meantime, notice has been issued by the Tahsildar and under Annexure 6, my lord. I am challenging under Annexure 6, my lord.
What are you challenging?
Challenging the not executing the notice, my lord.
That's not challenging,
Dated
sir. How
My
can
lord.
you say challenging not executing notice? I have not heard of something like this. You want a direction to follow up on that notice he has issued, correct?
My lord, I am complying the notice, my lord. Not challenging.
To implement that notice.
My lord, my lord.
What was the date of that notice?
17/6/2022, my lord. Under Annexure 6, my lord.
No. Is there an OPLE case registered? What is it? It's an ODR.
Page 26.
How are they numbering matters like this? It's such a dim page. How are they numbering it? They've not marked any defect. How is it? How are they accepting this Annexure 6?
Page 26 is not eligible.
How are they?
This is a notice issued by the Tahsildar pursuant to the direction of the Honorable Court. Not a case.
How is it not marked as a defect?
So at the meets, he has again filed another writ petition. Now the exercise should have been completed at the instance of the Tahsildar first, then he can approach the.
You say the registry will furnish an explanation how this writ petition was numbered when the document which is being relied upon is illegible. Which is this? To be listed only after defects are removed.
Item number 12.
12, my lord, same matter. Petitioner filed the above writ application for direction to the opposite party number 4 to 6. Evict the unauthorized occupy the land of the petitioner.
So there is no requirement of filing translated copies, is it? Under our rules?
And it is required.
How are they numbering it like this? No need for translations. There's no need for
one time filed.
You say the ORIA documents being annexed are both illegible and not translated. The registry will furnish an explanation how this petition was, no defects were marked in this petition.
Some time may be allowed. I filed translated copy.
To be listed only after defects are removed.
Item number 13.
May I plead, my lord? My lord, this matter related to take the appropriate step to permanently evicted the unauthorized occupants from the public land, Gochar and Gramya Jungle, my lord.
All right, the petitioner's representation, bracket annexure 6, shall be examined by the Tahsildar Hatadi. And after notice to the petitioner and opposite parties 6 to 9, a reasoned order shall be passed not later than 1st August and be communicated to the parties within a week thereafter.
Item number 14.
Obliged.
Item 14, my lord, on behalf of Mr. A.K. Parida, may kindly be permitted to withdraw.
Dismissed as withdrawn.
Item number 15. Item 15.
None appears dismissed.
Item number 16.
May I please, Your Lordship? My lord, some encroachment appeals are pending before the opposite party number 2, madam. It is pending. There may be disposed of within a stipulated period. By virtue of this order of this honorable court, Tahsildar has initiated encroachment proceedings. Thereafter, they have preferred the writ petition before this honorable court. And that by the annexure 6, my lord, by the direction of this honorable court, the encroachers have filed an encroachment appeal, my lord. That is pending till now, my lord.
How was it? Sometimes it's PIL, sometimes it's single judge. I don't understand. There's no basis for numbering matters here. The earlier order is passed by a single judge, and now suddenly it's a division bench. All right. The only grievance
Encroachment appeal number 11
sought is that the sub-collector Baripada should dispose of. It's pending in the sub-collectors.
Yes,
Sub-collector Baripada.
ENC bracket A number 11.
Encroachment appeal number 11 of
2020 pending before him in a time-bound manner. Paragraph. Since given the limited nature of the prayer, a direction is issued to the sub-collector Baripada, if not already done, to dispose of the aforementioned ENC A number 11 to 26 of 2020, after hearing all the parties affected and in accordance with law, not later than 4 months from the date of receipt of a copy of this order. Paragraph. The registry will forthwith communicate this order to the sub-collector Baripada. The petition is disposed of later.
My lord, 16th encroachment appeal, sir. Encroachment appeal number 11 to 26.
Yes.
Item 17.
May I please, Your Lordship? The petitioner have filed this writ petition with a prayer to evict the unauthorized encroacher who have occupied the government land in both sides of the road. For construction of the road, they have filed the writ petition. Your Lordship, kindly have a glance to annexure 4 at page 21, my lord.
Sir, come to the cost title, sir.
My lord. My lord.
Tell us which of the opposite parties are the encroachers.
My lord, opposite parties are, sir, mainly in both sides of the government roads, man.
So which of these opposite parties are the encroachers?
My lord, in both sides of the road, mainly.
Sir, please understand the question. I won't repeat the question after this, sir. There are 5 opposite parties in your petition, correct?
My lord, numbers of persons. With humble
kindly listen. Are you able to listen, sir?
My lord.
So how many opposite parties in your petition?
My lord, opposite party will be more than 100 because in both sides.
No. You come to your petition, sir.
My lord.
You are appearing in 5002 of 2023, correct?
My lord.
Tell us how many opposite parties in your petition?
Opposite parties numbers are 5, my lord.
Which of these 5 are the encroachers?
No, 5 are not encroachers. They are the government.
Why have you not made the encroachers a party?
My lord, numbers of persons occupied in both sides of the road. So it is not possible to all.
Then it is not possible for us to give you relief.
My lord, your lordship has a glance to annexure 4, so your lordship will at a glance can know what is the fact about this.
No, we cannot know, sir. We cannot pass orders in the absence of parties who will be affected by our orders.
My lord, with due respect, I want to say that, my lord, it is duty of the government officer to evict the unauthorized and
So it is your duty to make those so-called unauthorized persons parties. If you're not interested in doing that, we are not interested in passing orders.
With due respect, your lordship, kind of unless for the government officer has written letter to the Tahsildar for eviction of the unauthorized for expansion of the road, my lord.
Yes.
So only
despite the court repeatedly telling counsel for the petitioner that unless he is prepared to make the alleged unauthorized occupants parties to the petition, the court cannot interfere. The counsel for the petitioner refuses to accept this obvious legal position. In that view of the matter, the court is unable to interfere. The petition is dismissed.
My lord, this is a PI, my lord.
18.
18, my lord. OP number 4 and 5 are the unauthorized occupant over government land. Representation under Annexure 4 at page 16. And it has been duly delivered by the Annexure 5 and 6. I have filed postal receipt and tracking report. Annexure 4 is pending for OP number 2.
All right. So the petitioner's representation, bracket Annexure 4, will be examined by the Tahsildar Patamunde, and after notice to the petitioners and opposite parties 4 and 5, and after giving them a hearing, the reasoned order shall be passed not later than 1st August and be communicated to the parties within a week thereafter.
Item 19.
19, if I may please your lordship, my lord. My lord, the petitioners are villagers of village Kartang. My lord, they are aggrieved by the inaction of the opposite parties, wherein despite various representations being made to them and despite being given at the grievance cell, my lord, no action is being taken.
The petitioner's representation shall be examined by the collector.
My lord, may I pray for the Tahsildar because the Tahsildar.
All right.
Annexure 1
shall be examined by the Tahsildar Binika. But whom are you? What is your prayer?
My lord, my prayer is there are certain number of these government lands. My lord, time and again there have been
encroachment.
Illegal
encroachers.
Again, encroachers not made a party, sir. Same story.
My lord, the representation is pending. If a lordship can direct them to consider, my lord.
You'll have to make the encroachers party, sir.
I'll make the encroachers a party, your lordship. Your lordship,
Counsel, the petitioner seeks leave to withdraw the present petition, liberty to.
My lord, I'll file an IA, your lordship.
You have to make pleading, sir. You'll have to.
But I'll file an IA for implementation.
You'll have to have amendment to the petition.
Yes, your lordship. I'll file
make governments respecting each of the encroachers.
Your lordship.
To file a better petition accordance with law. Disposed of is withdrawn with liberty is grateful.
Grateful, your lordship.
Item number 20.
In item 20, notice has already been issued. I mean, VC, my lord, the notice has already been issued. So the tracking report says, I mean, the status could not be ascertained, whether it has been delivered or not. It's the Regional Provident Fund Commissioner, my lord.
That's already appeared by opinion of 2 minutes. The appeal memorandum is incomplete, millet. The appeal memorandum is incomplete, millet.
Counsel for the respondent 2 states that the appeal memo served on him is incomplete. A complete copy be served on him within 2 days. List on. July.
Oh, bless me. I'll do that today.
Item number 23. Item 23.
My lord, the state is the appellant, my lord. The impugned order is at page 52. What has happened, my lords? In respect of a Gochara land, the Honorable Single Judge has directed the state to settle the same in favor of the petitioner. Admittedly, it is a Gochara land. And on the basis of what? On the basis of an order of Joint Commissioner passed in RP case. And that RP case is challenged by the villagers before the Honorable Court, that is in WPC 23319 of 2015, which is now pending. Number 1. Number 2, if your lordship will see, although the parawise comment was ready and submission was made by the State Council to file counter affidavit, the Honorable Single Judge was pleased to decline our prayer and pass the impugned order. solely basing on the order of the additional commissioner of consolidation that this land should be settled in favor of the petition. That order is now challenged before the Honorable Court. Your Lordship may see page 9 of the appeal memo at para C, page 9 of the ground number C. For that, the observation with regard to the challenge not made against the order passed in RP case now is a wrong finding.
It's pointed out that the judgment in RFA number, judgment of the District Judge Kyunjar in RFA number 7 of 2014. You challenged RFA order in
RP case number 91 of 2014.
All right, sorry, that the order dated 28
Paragraph
May,
C, page 9 of the appeal.
28 May 2000 and what's the date, sir? 28 May 2014.
Yes, madam.
Passed by the Additional Commissioner Settlement and Consolidation.
28th May 2014.
Has been challenged by the state.
No, challenged by the villagers.
Okay.
Para C of page 9 of the appeal memo.
This is stands challenged in writ petition civil 23319 of 2015 by some of the villagers of village and which writ petition is sub judice before this court. It is accordingly submitted that the learned single judge was in error. No, it's accordingly submitted that the statement purportedly made by the AGA before the learned single judge, to the contrary, has resulted in an erroneous order requiring the appellant to comply with the aforementioned order of the in RP case number 91 of 2014. Say notice returnable. August.
Stay of
the impugned order till then.
Item 24.
On behalf of Mr. Devasis, he is suffering from throat infection. I pray kindly take now next week, my lord.
Not cured so far. You don't file a copy of the judgment. All right, we see counsel for the appellant stated to be unwell. List on July 10th.
Okay. Item 25.
25, 26, 27, 28, DLR employees, 25th of April.
Tomorrow.
Tomorrow.
List one.
Up to 28. Yes. Item now 29.
29, 30, 31, 8th of May, Saptapeda case.
Item 32.
There is a defect, my lord. Noting is there, so I will remove the defect. 1 week time I will given.
Oh, sir, this is a 2021 matter.
I don't know. Let's be given one opportunity, so I will remove that.
What's the matter about? You got less marks from the last candidate. Come to page 28.
I have not gone to, so your lordship may put it next week. So
No. You have to come prepared, sir. This is
I
not-
am not prepared, my lord. So your lordship,
Sorry, we're not giving you
since
time.
the defect are there, so that is why I am not here.
You can't presume that. Sorry. If you want, we'll pass it over. You have to take the court more seriously, sir. Sorry. We'll pass it over. You get ready with the matter. Pass over.
So I am not there, so your lordship may put it, my lord.
Counsel for the appellant is refusing to argue the matter.
Not refusing, my lord. Your lordship may I pray tomorrow, your lordship.
You be prepared to hear you today, sir. We will pass it over. You better get ready with the matter. Make your submission. All right. Pass over.
Item 33.
33.
Yeah. Challenging the order passed by the Honorable Single Judge under Annexure 6.
Yes.
And the operating person, your lordship, may I read what's Annexure page 39, paragraph 4. May I read your lordship?
Yes.
Mr. Warren, additional government advocate for the state submits that the order passed in LEC case number 58 of 1983 is inexecutable in as much as the Tahsildar Conisi, while exercising power under the provision of the Act, has no jurisdiction to the record any finding with regards to the correctness of the ROR published under the Odisha Survey Settlement Act 1958. Further, the petitioners have not moved the competent court of law for a recording of the case land in their name within a reasonable time. The case land is the government property and is being used for a public purpose. Thus, the prayer of the petitioners in the writ petition should not be entertained. Accordingly, the prayer for dismissal of the writ. Your lordship, may I submit, your lordship? May I read the entire order, your lordship?
Please, you have to argue the case, sir. Don't take permission for every step. You argue it whichever way you want to argue it.
Your lordship, kindly see the running page 26, your lordship. The order passed in LEC case number 1983.
Yes.
58 of 83.
Yes.
General notice duly published and no objection received. This case was started basing on the ROR entry, plot number such and such covering an area such and such Ralaba village is recorded under the Ajay Khata with a note of Jabardakal in the name of Jagdish and Balaram Acharya, son of late Nursing Acharya of Rangipur, and the classification is noted as weight 2-1. It has been noted in the remarks column against the case plot in ROR that the case land was an inam and as per the previous settlement records. The encroachers appeared and during the course of inquiry, they produced registered deed number such and such dated 31/7/1956 through which an extent to 1 acre 44 decimals out of survey settlement number 1 was purchased by both of them. This is Sabik survey number 1 corresponding to Hall plot number 288, that is the case land. On further scrutiny of revenue records and RORs produced by the encroachers, it disclosed that under section 7(1) of the OEA Act, the case land was settled in favor of the encroachers in CP case number 1141 of 1966 in the year 1969-70, and the RI has opened a royalty khata bearing number such and such basing on the rent schedule. Rent was demanded up to 31/3/1976 as per Sabik records, and subsequently rent for this plot has noted been demanded as the plot has been recorded under the government khata in the final ROR, which came into force 1/4/1976. This is therefore an error which would have been averted had the parties approved the settlement which their claims, and also the Tahsildar intimated the fact of settlement of the land to the settlement authorities in time. Next page, your lords. Since the case land has already been settled and a royalty status assigned prior to the finalization of ROR, the entry made in Ajay Khata is therefore not in a conformity with the evidence on record.
How could the Tahsildar come to this conclusion? He has no jurisdiction to say this.
The land encroachment case, Your Lordship.
So he has no jurisdiction to say some entry is incorrect or yeah, correct. That's not within his jurisdiction.
Lordship, that the government has initiated land encroachment case. The order passed by the Tahsildar is the authority to pass an order.
The ROR. So the correction of ROR is not his. This does not give him jurisdiction. Not this proceeding. In the encroachment case, he can't talk about the correctness of the ROR. That is under the OEA.
OEA case, Your Lordship, already settled.
Yes.
OEA case number 141 of 1996.
Yes.
The OEA collector has already settled the land in favor of the petitioners.
Yes.
The OEA collector in OEA case number 41 of 1966 already settled the land in favor of the petitioner. Lords.
All right.
That the honorable single judge.
Correction of ROR is a separate proceeding, sir. You don't confuse the correction of ROR with this.
That is the
encroachment case.
That is the because that was under the OPLE Act, that
OPLE.
encroachment proceeding.
Correct.
And this is under the OE Act. The same authority cannot exercise the power and came to a conclusion that the ROR is erroneous. It is not. It should not have been recorded in favor of the government.
Your Lordship,
that is the finding of the honorable single judge.
May I submit, Your Lordship. The OEA collector has already passed the order to settle the land in favor of the petitioner. In spite of that, the land has been recorded as a J khata. Therefore, OPLE proceeding has initiated against the petitioners. After the order passed by the OEA collector, the honorable single judge, Your Lordship, may I read the entire order, Your Lordship?
Yes, entire order.
Page 37, Your Lordship.
Page 40.
The petitioners in this applicant seeks for a direction to the additional Tahsildar Konisi, opposite part number 3, to record the land in question in their names, pursuant to the order dated 22nd October 1983 under Annex 2, passed by the additional Tahsildar Konisi in LE case number 58 of 1983, and the order dated 19 March 2019, passed by this Honorable Court in WPC number 5790. Already once this Honorable Court has directed the Tahsildar to implement the order passed in LE case number, LEC case number, as per the order passed by the Tahsildar in land encroachment case. Therefore, the petitioner filed an application, representation along with the order passed by this Honorable Court. Since then, the Tahsildar has not taken any steps. Therefore, the petitioner again approached in the present writ application WPC number 12,337. Once this Honorable Court, the Honorable Single Judge has already directed to the Tahsildar to carry out the order passed in land encroachment case. Therefore, thereafter, the petitioner filed an representation along with the copy of the order passed by this Honorable Court before the Tahsildar. Due to non taking any steps, the petitioner again approached, praying that the order passed by this Honorable Court has not been carried out.
Yes.
Thereafter, the honorable single judge has dismissed the writ application.
All right. The present appeal is directed against an order dated 6th August 2021, passed by the learned single judge, dismissing writ petition civil 12337 of 2020, filed with the present appellants, in which they sought a direction to the additional Tahsildar Kanesi to record the land in question in their names, pursuant to an earlier order dated 26 October 1983, passed by the additional Tahsildar Kanesi in LE case number 58 of 1983, as well as an order dated 19 March 2019, passed by this court in writ petition civil 5790 of 2017. Paragraph. The learned single judge has noted that in the order dated 22nd October 1983, Tahsildar took it upon himself to observe that the entry made in the Anabadi Abad Jogya Anabadi status in government khata in the final ROR was erroneous. And open quotation, not in conformity with the evidence on record. Paragraph. The said order was passed in a land encroachment case under the OEA Act.
No, OPLA Act.
OPLA Act,
OPLA,
right.
Orissa Prevention of Land.
Whereas the entry in the ROR was under the OEA Act. Full stop. The learned single judge has rightly observed that the additional Tahsildar Kanasi, while dealing with a land encroachment case under the OPLA Act, had no jurisdiction to declare an entry in the ROR to be erroneous. Full stop. That was clearly outside his jurisdiction. Paragraph. Counsel for the appellant sought to rely on the earlier order passed by this court in writ petition civil 5790 of 2017, where it is observed that in the event there is no challenge to the proceedings in LEC number 58 of 1983, then both parties will abide by the said order. Since the above order, as noted correctly by the learned single judge, was itself without jurisdiction, the appellants could not possibly ask for its enforcement by way of a writ petition in this court. Having heard learned counsel for the appellant and examined the parties and having examined the impugned order and the other documents placed on record carefully, this court is unable to find any ground made out for interfering with the impugned order of single judge. The appeal is accordingly dismissed.
Item number 34.
Lord, Annexure 9 at page 35 is the impugned order, by which the Honorable Single Judge dismissed my petition on the relying on the judgment of in Navin Kumar Bevra's case, by which precondition of Section 5(2) of Orissa Education Act was relied upon, where prior to appointment of an additional section teacher, a permission was necessary. My ground to challenge on this judgment is that the Honorable Single Judge has not taken into consideration as to when Section 5(2) came into the statute book. My appointment is of 1991. The provision at Section 5 was introduced by way of amendment in 1994. So as on the date of my amendment, prior permission requirement was not there in the statute.
So you ceased to be in service in 2001.
In 1991.
No. You ceased to be in service after 23rd August 2001.
That was they prevented not to come to because my appointment was not approved. So I approached the tribunal in with this honorable court, by which your lordships directed for consideration, and after consideration it was rejected, and that rejection order was under challenge before the tribunal in 2016. Large number of additional section teachers similarly situated have been approved.
No. The proposal was submitted on 27th April 1994 for creation of posts. But by the time it could be considered,
The date of appointment is material. Proposal was submitted in 1993. Prior to 1994, that is your lordship see at Annexure 5, page 27, that is of 10/7/93. That is this statement giving the detailed roll strength, etc., etc. Proposal was called for by the government via Annexure A4 and submitted in Annexure A5. That was of 92.
No, Section 5, subsection 2 came into effect when? What's the date of coming into effect of Section 5(2)?
Section 5 entirely came into statute by way of amendment in 1994.
Must be a date, sir.
Date is not there in the book. I searched for it. I will have to search from the notification, date of notification.
No,
But
what
in
is
the-
your ground then?
in the
Obviously,
manual-
by the time it's being considered, the Section 5(2) is in force. The school is taken over on 7 June 94.
94. By the time of my appointment, prior permission was necessary. That was the ground on which Honorable Single Judge rejected, dismissed my prayer.
Correct.
So my contention is that as on the date of my appointment, when the managing committee appointed me, prior permission by the managing committee was not
That's
necessary.
right, but the management committee itself applied to the government for creation of additional posts.
In 1993.
Whatever. So it was not considered, by the time it was considered,
So
Section 5(2) came into force.
Post facto approval was permissible prior to 1994.
That's right. Prior to 94 it was, but for some reason it did not happen.
It was delayed at the level of the government personnel. I do. A large number of additional section teachers were approved in 2000 by order dated 24/2/2000, as I remember.
See, everything is just from memory. No need for facts.
701 persons were approved.
By memory, we can write judgment.
But in my
no
case,
need to plead facts, nothing. Everything through memory. Even date of coming into force, sometime in 94, we have to write sometime in 94.
I searched 3 educational manuals today. Each page I searched what is the date. Nowhere I found it.
Then?
So I have to search the Gazette notification. That is the date. I can procure the Gazette notification within 2 days, no problem. But
Also for the appellant needs time to properly prepare his arguments and submit a date chart. List on.
Copy of the read.
I'll supply.
Copy of the read will be served on.
Item number 35.
Lordship add-on to
18th July.
Lordship fix a date.
18th July.
18th July.
Item 35.
And this is the case which your lordship had the occasion to deal with, where in the first day itself direction was issued for regularization. In one of the case, this noble court held such kind of direction should not have been given. But here there is one difficulty. That was my initially thinking the direction of the Honorable Single Judge to be a direction for consideration, we disposed of and withdrew the appeal in this case that is before your lordship today. But in the other case, which triggered manner filing of all these appeals, because in the contempt, it was held that this is a positive direction, that first order your lordship will see. That is the case where your lordship has been pleased to recently set aside, and there are many cases, at least 7-8 cases where your lordship has been pleased to set aside, remand the matter to the Honorable Single Judge, directing that it should be considered on merit. But on the first day hearing the State Council, even the Civil Supply Corporation was not noticed. All cases were disposed of, my lord.
Notice returnable.
My lord, the other case is same. May I, with your lordship's kind permission, furnish four more numbers which are same, so that it can be taken on board and notice can be issued and had together, my lord.
All right.
I am furnishing in the shape of a memo, my lord.
All right.
Deeply grateful, my lord.
Those three matters taken on board. Say notice returnable.
Okay.
16th August. There should be a stay of the impugn order till then.
Much obliged.
Item 37.
Yeah. My lord, the aggrieved order, my lord, under annexure 2, my lord, in page number 31, my lord. In para 4, my lord, of the order, it is quoted that the London Council for the petitioner contended that when the lease proposal is pending before the Revenue Divisional Commissioner, North Division, so far as the allotment of the land in favor of the school is concerned, now the mega power project has come over the same area, which overlapping the area, which is to be granted on lease in favor of the school in question. So, my lord, a school is existing. A government school is existing from the year 1989, my lord.
Next, para also important. Para 5.
Para 5, my lord, the learned additional government advocate brings to the notice of the court that the letter number
2nd September
2921, wherein the Tahsildar Hindol has clearly indicated that the proposed land is lying vacant and the Panchayat High School Khoridali is not using the proposed land, it is beyond the school boundary area. Further, the proposed spot is suitable for the purpose of establishment of the mega drinking water project, my lord. So, my lord, the whole contention, my lord, when the lease proposal is pending before the approval of the RDC North Division for the area 3 acres of the land, out of 7 acre 31 decimal of the government land. Out of 7 acre 31 decimal of the government land, the lease application filed for the area of 3 acres, and that has been approved by the Tahsildar Hindol and RI Baband has clearly reported on the Annexure 2 series, my lord, that the area 3 acres is suitable for the lease and the school is existing and the school is using the land. In the meantime, one mega power project, mega water project is introduced, and from the same area, they are trying to take away the land from the lease area, my lord, of the 3 acres of land.
My lord, may I submit, my lord?
Yes.
It is alleged by them that the lease proposal is, that is what I wanted to raise as a preliminary objection, that the lease proposal is pending before the RDC. That is their allegation. And your lordship will find RDC is not a party to the writ petition. Otherwise, the Honorable Single Judge could have asked the RDC to dispose of that lease proposal. I do not know whether the lease proposal is pending or not, because see, the RDC, so the very writ petition suffers from non-joinder of necessary party. Number one. Number two, the Tahsildar letter which the Honorable Single Judge has relied upon, maybe it is you have applied for lease, but lease has not been granted. It is a government land. And government is going to raise a project which is beneficial for the larger interest of the people, of the villagers. It is not, and school is not affecting.
But even a school is a public purpose only, sir.
That is what, but that this area of the school is not affected. That is what I...
Why don't you find out where is the status of that proposal of the RDC?
Yes, that RDC may be included as a party, so that I can, because that I was finding out. I did not send any letter to the RDC, that is because there is no, he is not a respondent in this appeal. So the...
All right, and the oral request to the counsel of the appellant, the Revenue Divisional Commissioner, North Division, Sambalpur, is impleaded as respondent number 5. A copy of the writ will be served. You've got a copy. You've got a copy, sir.
I have got a copy for other respondents.
All right. The consolidated cost will be filed within a week. You say Mr. D.K. Manthi, learned additional government advocate, states that he will ascertain from the RBC what the current status of the application submitted by the appellants. No,
Forwarded by the, as per his case, it is forwarded by the Tahsildar. Lease proposal has
current status of the lease proposal forwarded by the Tahsildar, whereby the school has asked for an additional 3 acres.
Allotment of the land in question.
Yeah. That is request list on 10 July.
10th July.
Item 38. Item number 38, your lordship. 24/2023. State has filed the counter affidavit. I have to file a reply, your lordship. 24/2023. Pursuant to your lordship's order, we have filed the
14th of March. Your lordship, on 14th of March, my lord, passed the following order. My lord, your lordship may kindly see that order. Mr. Isindas Leonard, additional standing counsel for the state, will inform the court how many GRS are deployed in all over the state of Odisha and if there is any scheme or policy contemplated for the regularization. An affidavit in this regard be filed before the next state member.
Lord, all right, you say pursuant to the order dated 14 March 2023, Respondent 1 has filed an affidavit which is handed over in court today. Counsel for the appellant seeks time to respond to it before the next state. List on 17 July.
Obliged, your lordship. Item 39.
In 39, your lordship issued notice. None of the appearance have also intimated who was appearing for before the honorable single judge. He refused to receive the notice.
First day disposal.
First day disposal.
All right. The office noting is that the counsel who appeared before the learned single judge for the respondent has refused to accept notice. Respondent 1 has refused to accept notice. Paragraph. Since the impugned order was passed on the very first day, without opportunity to the petitioner, the present appellant state, to file a reply, the impugned order is hereby set aside. The matter is remanded to be restored to the file of the single judge, the roster bench, where it will be listed for hearing on. We'll have an earlier date. 17th May 2023. Since the respondent herein has not appeared, the single judge will, if the respondent number 1 is not present, proceed in accordance with law thereafter. The writ appeal is disposed of in terms.
Item number 40. 40, 41, 42. 3 matters, same matter.
Again, you served it on counsel.
Yes.
No, 40 this.
In second case, your lordship issued notice and that has been delivered.
Delivered.
Yes. But none.
44. I'm appealing for
44. 41, 40.
All right. 40, 41, 42, 43.
41, 42.
40, 41, 42, you say despite delivery of notice, none appears to the respondent. Paragraph. We've seen that the impugned order was passed on the very first day without opportunity to the appellant to file a reply to the writ petition. On that short ground, it is hereby set aside. And the writ petitions are restored to the file of the learned single judge in the roster bench, where they will be hearing on 17th May. Since the respondents have not respondent number 1, sorry, the respondent writ petitioners have not appeared. The learned single judge will proceed on that date. after one notice to the writ petitioners.
In 41, my lord, there is a noting. It return, my lord, 41, there is a noting. Address cannot be located, hence return to sender. So notice could not be sufficient, my lord.
All right. In 41, you say the notice has been returned saying addressee can't be located. And then you pass this out. Right.
Item
42
43.
delivered. 42 delivered.
Item 43. 43, my lord, Lordship may see the noting, my lord, notice could not be issued due to late filing of the requisite. That may be accepted, my lord, already filed.
The requisites already be filed. Or what is the matter about?
My lord, this is regularization of DLR employee, my lord.
Coming up
Lordship is-
tomorrow.
yes, tomorrow, my lord.
Then just simply place it tomorrow.
Math.
44 also.
Item 44, my lord, senior has appeared.
My lord, I am appearing today, my lord.
Tomorrow, Lordship will call it tomorrow, my lord, 24.
Time for counter, my lord. I have to
Not necessary, sir. Tomorrow it will come up.
Item 45. 45 also same, my lord, DLR employee. Lordship may kindly see the noting, my lord. The requisites have
It's all
been
right.
filed
We'll
late.
see tomorrow.
Tomorrow. Item 46.
46, today we have appeared and filed Vakalatnama. Your lords may fix any other date.
What matter is this?
This is not Thursday, this is a regularization matter. Not Thursday. That is transferred from State Administrative Tribunal.
All right. At the request of counsel for the respondent, list on.
Right.
August, interim order to continue.
Item 47.
47 was rehabilitation assistance scheme 30th August.
Item 48.
48 my lord, dismissed similar matters. Similar matters will also be dismissed.
In view of the order dated 4th April 2023 in WA number 1321 of 2022 bracket State of Orissa versus Vijay Ketan Vidyadhar Sahu. The present writ appeal is dismissed. Sorry.
Item 49.
49 job contract 14th September.
14th September.
Item 50.
50 promotion during pendency of vigilance case 11th May.
11th May.
Item 51.
Similar matters have been fixed to 12th July.
All right. Same.
51, 52, 54, 55, 56, and 57.
All 12 July.
Except 53. 53 is a different matter.
53 is?
Different matter. That's the union government. 51, 52, 54, 55, 56, and 57.
Yeah. 53.
53, my lord, petitioner is out of station. He has filed petition, my lord, the case in person, my lord. The lordship may call it next week.
Petitioner who appears in person is not present today. List on. July.
Obliged.
Item 58. Lord, 58, 59, 60, 61, 62, my lord, 25th of April, tomorrow, my lord. This is pension scheme. My lord.
Okay.
Item 63.
63 work judgment 14th September.
Lord, I am appearing on for respondent, my lord. We have entered our appearance, my lord. We have also filed the Vakalatnama.
Or
My lord, may direct to serve a copy on us.
I'll search.
Item 64.
64 old pension was Yes, two more, my lord. Fixed.
All right.
Item 65.
Madam, 65 petitioner appellant will challenge the inter-seniority list. Defect has been
All right.
dictated by
List
not-
on.
'Appellant is the
3rd July. Effects be cured in the meanwhile.
Item 66. 66 laboratory technician, 20th July, man.
Right.
Item 67.
67, my lord.
67, I have filed the caveat petition. Copy of the appeal memo may be served.
My lord, single day disposal, my lord. What should we see? Page 21.
What do you say, sir? We should go back?
Your Lordship may remedy the matter.
All right. It is seen that the impugn order was passed in the very first day without opportunity to the appellant to file any reply. On that short ground was hereby set aside, restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 1st August. The appellants will file their paragraph reply not later than 24th July. And the respondent petitioner will file a rejoinder thereto, if any, on or before 1st August 2023. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the writ petition merits and dispose it off as expeditious.
Small copy of the written.
All right.
Item 68. 68, the Lordship, page 26, the impugn order. This is different from that. It has been covered with that Patitavan, this is Anganwadi supervisor, my lords. Not similar matter. Your Lordship is fixing to 11th July.
11th July.
Item 69.
69, my lord. 8th of May, my lord. Sub case.
8 May.
Item 70.
Item 70, sir.
My lord. Sorry, pardon to 66, my lord. I was. Lord, in 66, I am for the sorry.
Adjourned to 20th July.
20th July, sir. 66.
Obliged, my lord.
Item 70.
Also.
Item 71.
71 and 72, my lord. 14th of September, my lord. Work charge.
Right.
Item 73.
73, my lord.
Your Lordship, item 70, Your Lordship.
Yes. He's unwell.
Lordship?
He's unwell.
Yes, Lordship.
All right. Counsel, the appellant is unwell. List on.
Oblige, Your Lordship.
73.
73, my lord. Stated the appellant, my lord. The learned single judge, Lordship, may kindly see running page 16, my lord. Here he was a applicant for a post of constable. He has filled up his form. He has given, my lord, he has not declared that there's a pendency of criminal case against him. 3 number of cases were pending. Subsequently, after, my lord, some time he has been acquitted in those criminal cases. And on that ground, he has filed a writ application saying that subsequently he has been acquitted. Therefore, I may be reinstated. The learned single judge, my lord, proceeded on the matter. What you may kindly see page 17. He had not filled up the form. Our case is, my lord, if he has not filled up the form, my lord, it's negligence on his part and he has suppressed the information, my lord. But learned single judge proceeded on the finding, para 27, page 23, Lord, you may kindly see that he was honorably acquitted. Our, my lord, second ground of challenges, my lord, the matter in which he has been acquitted out of 3 matters, in 2 matters, the matter has been compromised. It has not been recorded as a compromise matter. It has not been honorably acquitted. That's our case. The fact of my lord, acquittal has been given by the petition appellant. I'm sorry, respondent in the my lord reply to the counter which we have filed. In the reply to the counter, we have filed another reply to the reply, my lord. There we have taken help of 2. We relied upon 2 judgments of the Honorable Supreme Court, which was not discussed by the Honorable Single Judge. That's only ground.
It's a notice returnable. 18 July. There shall be stay in the meanwhile.
18 July. Item 74.
74 rehabilitation 30th
August.
Item 75.
75 मतलब outsourcing 8th
August.
Item 76.
76 मतलब RSCP pay 35 first day disposal.
In this case, what happened, my lord? The earlier tribunal they had approached before the tribunal, my lord. I don't have a readable copy, but on the basis of this writ petition copy, I am saying earlier the petitioner had approached the tribunal, and tribunal directed to grant the RSP benefit. And on the basis of this order of this law and tribunal, the authority has implemented the order. But they grant the RSP benefit with effect from 1/1/2013 to 3/2/2013. On the ground that the deputy engineer post is come with existence with effect from 3/2. My prayer is that while the government has been allowed the benefit on the basis of the tribunal order, comply the order of the tribunal with effect from 1/1/13, how they will be reduced with effect from 3/2/13? On the basis of that 3/2/13, new resolution came that deputy engineer post is came between the assistant engineer and engineer with the same scale of pay. On that ground, if a person has been promoted with a high scale of pay, how can they will be reduced with from 3/2/13? Subsequently, and on the same issue has already been decided and implemented by the works department and granted all the benefits. For that reason, this honorable court observed that.
Interim order. What you challenge is an interim order.
No, it's a final page 35.
Since we had already approached tribunal, this honorable court observed that again we have to, and works department already implemented.
The only difference, my lord, the implementation of the orders in those cases, that the post was upgraded on the restructured on 3/1/2013. Those who have completed 30 years prior to 3/1/2013, they were covered under the old rule. Those who are completed 30 years after 3/1/2013, they were covered under the new rule. So this man has completed 30 years on before 3/1/2013. So his grade pay was fixed on 5,400.
6,600.
Not
allow the benefit.
You are not allowed 6,000.
6,600 allowed the benefit, my lord.
Then why you have come to the?
I don't know. But after 3/1/2013, they have reduced. So, on the ground that the deputy engineer post has been came between the assistant engineer and engineer.
So you have to file a counter. My lord, that is the only.
My lord, the entire all the works department all are getting the benefits. The petitioner will suffer a lot since long, and on the basis of the order of the law and tribunal, they implemented the comply. And they grant the benefit with it from 1/1/13. But with effect from 3/1/13, then again reduced.
No, but the only point he's making is it was disposed on the very first day, no reply filed, nothing.
My lord, that I am submitting, my lord, on that basis, my lord, that he already approached the tribunal, my lord. And the tribunal passed order, and the government has implemented the order.
Tribunal after.
Not in your case, sir, in other cases.
No, my lord, my case.
No, but subsequently.
May I pray, my lord? Kindly taken up tomorrow, my lord.
No, but subsequently they reduced the benefit, correct, in your case?
Yes, my lord.
So you went to the writ petition. My
lord, that part, as was the works department already grant the benefit to all the persons.
All right.
And on that basis,
they reduced the benefit after initially granting it. Subsequently, they reduced it.
My lord.
So you were aggrieved and you went before the single judge.
Yes, my lord.
But without any counter affidavit being filed by them, on the very first day, your writ petition was allowed.
Yes, ma'am. On the basis of this observation,
contest, there's no problem. We are not compelling you. You want to contest, you by all means contest it. You say notice, he accepts notice on behalf.
But then it is sent it to the single judge because otherwise the petitioner already retired and they are suffering a lot, and in the tribunal order they have been implemented.
All right. It is seen that the impugned order was
Sorted,
passed by
my
the
lord.
learned single judge on the very first day without any opportunity to the present appellant to file a reply to the writ petition. On that short ground, it is hereby set aside in the files and the matter is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 8th August. The
No,
state will
prior
file
to
its
that-
parawise reply to the writ petition not later than 1st August. And the respondent writ petitioner, if he so chooses to file a rejoinder before 8th August, no further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the matter thereafter on merits and dispose it of as expeditious as possible.
Item note 77. My lord, this is sub the period 8th of May, my lord.
All right.
Item 78. 78, 79, 30, my lord, 14th of September, job contract.
All right.
81. 81, my lord, 14th of September, my lord, this is regulation matter.
All right.
Item 82.
82 is similar to item 51.
All right.
12th July. Item 83.
83 में regulation. Election में page 60.
It's a fresh matter, sir.
First day.
No, fresh. There's no
notice.
No. This kind of matter is
this can be fixed to tomorrow because these are DLR matters. It can.
All right, tomorrow.
84. 84 में job contract 14th September.
Right.
Item 85.
85 में 30th August rehabilitation.
Right.
86. No, 86, 87, 88, 90, 14th of September.
Right.
Item 91.
89. That is 89.
86, 87, 88, and 90. Sorry. Item 89. Please.
Pass.
It's my lord, 89.
Yes.
My lord, 2 days we given to remove the defects, my lord.
All right. So list on 3rd July, defects be removed.
Problem.
Item number 91.
Yeah. Say none appears for the appellant. Defects be removed. In the interest of justice, defects be removed before the next date. List on 3rd July.
Item 92. 8th of May, my lord. Item 93.
Your Lordship.
Defects have to be removed.
Your Lordship. May I please, Your Lordship? The appellant challenges the legality and validity of the order passed by the.
There are defects to be removed, madam.
Your Lordship.
13 July, defects be removed.
Item 94.
94, 14th September. Job contract.
Item number 95.
My Lordship. Lordship, this petition which is seeking for extension of the fee waiver benefits which was granted during COVID to the students in private schools. Not all the pleadings are completed and it was for the stage of final arguments, my Lord. But in this petition, which is in the form of a...
Whereas who's appearing for the SNME? Earlier, Mr. Mahapatra was appearing.
In this case, I am appearing for SME. Let's fix another date.
Lord, already, my Lord, the academic session of this year has also begun.
Any day next week.
Already, and the fee waiver dates back to academic year 2021. So in that case, it is already, and the previous orders have still not been implemented. We have so many writ petitions which are pending for the previous order which was passed by this honorable court. Not
Say,
unless
Mr. Kuntia states that he has just been entrusted the brief for the SNME department at his request list on. We'll have it on the earliest. 26th June. 26th June. Right.
Item 96.
Nice.
Item number 96. Hey.
Reply was to be filed. What happened?
6.
Reply was to be filed. This is about not providing jobs to persons with disability. Last opportunity is granted to the state to file a reply.
Copy has not been served. Our office noticed that there is no copy served to us. Defect number 6 is there.
All right, we'll just pass it over once.
Item 97.
97, my lord, just now my senior has served me the compliance affidavit.
That compliance, your lordship has directed to cause an inquiry.
And my senior has also served me the copy of the affidavit. I have to take instruction now.
Lord, it's a question. I am the highest bidder and I have not been able to operate the source on account of objection of these villagers. They are saying that the safety zone is violated. That's the reason your lordship, referring to Rule 30, specifically directed the state to file an affidavit to carve out the safety zone, or if at all it's permissible or not permissible. If
No, it's not prudent, it says.
Beg pardon, man.
Due to upcoming of a new important project, that is canal siphon at upstream and prohibition for movement of heavy loaded vehicle over flood protection embankment. Further continuance of the source is not prudent.
Not prudent. Not prudent. So let them refund my money, you know. They are holding my money since more than a year.
Then return it.
I'll take instruction.
No, let's pass the order. Why to make a deal with this? My amount is lying idle with them. There is no point in
pass an interim order observing the findings of this report, and I will set instruction what is the status.
Once they have said that it is not viable,
has forwarded the report dated 17th April 2023 regarding safety zone of the Papuria sand bed at Sarai over River Kusai. Full stop. The report, the joint verification report concludes that in view of the, it concludes as under, just say A to A. Paragraph is the PK rather council appearing for opposite party number
6. My senior is for 6.
6 states that in view of the above report, the money deposited by opposite party number 6 should be refunded to him.
Yes.
Mr. Mohanty seeks time for instructions. List on.
Sometime next week, my lord. Only both the matters to be disposed of with that observation.
15 days.
That's all. There is no point in keeping these matters pending. Once you are saying that it's not viable, end of the matter.
We'll have it on 16th May.
16th May.
16th May. That will do. Grateful.
Item number 98.
98. Sartapada, you'll also make can fix it to 8 May or all some of them have appeared.
In WA 570 2021, my lord, I have filed today Bhaklatnama.
No, what is it?
This is first day
disposal.
Today I filed Bhaklatnama only. Well,
you want to go back in a time bound manner to the single judge?
I am giving that similar orders.
Just give it to us.
Oblige.
So it will be listed for hearing on You just say 21st August. Reply will be filed on or before 8th August. Status quo be maintained till then. Till disposal. Status quo will be maintained. So this is the same order we're going to pass on 8th May, is it?
My lord, my.
I see.
We want that on merit it can be disposed of, because again we have to file count on all the cases.
You have to. That's the price you pay. For you also, like they are doing copy paste, you also do copy paste. They all do that when they file 400 and 500 petitions. The contempt petition is closed in view of the above order. 1360.
All the cases.
In all the cases, this order. Right. They've all entered appearance. I think you just have to put their names. There are names of each of them.
Fix it on 8th May, my lord. On 8th May?
No. Just give the dates. 21st August is when it will be listed, but by then pleadings will be completed. And no further time will be granted.
Similar matter in school case matter that is posted to 8th May matter.
The other matters, if you're there, we can take it on board today and finish it off.
No, madam, this is only today for appearance date.
That's what. So that on 8th May, you know what order is going to be passed. So because on 8th May, we have how many matters? Already 538 matters.
My lord.
So I don't know how we'll have to have a special day for this whole batch of matters. Or you stagger it. We'll stagger it.
Yes, it will do better.
What we can say, it will be listed for directions. And it will be open to the single judge to stagger it.
Well,
can we do that?
8th May.
8th May, let's see, posted 8th May.
All right. These matters, let it go. I mean, let it go for 21st August. Let these matters go to 21st August. Those will say that it will be open to the single judge to stagger it.
In this case, this is a school matter. This is two different matter. This is a college case matter, school case matter. School case posted to 8th March.
School case.
Lordship posted that matter to 8th March. Well, that day I will have matter.
That's what. So you come on 8th May again, no problem. This we are anyway posting it, sir. This is over. Now this will go before the single judge on 21st August. You complete pleading.
Item 99.
So 99, your lordship has already issued notice.
99.
These matters, your lordship can fix it to tomorrow when similar matters are coming to.
Correct.
Item 100.
State of Orissa. 100.
In this case, already notice has been issued on 16/3/2023. This can be fixed also tomorrow, man.
Tomorrow, is it? All right.
Password.
How can you know? Requisites not filed here.
This one is gone on the.
Oh, valid service. It's been returned after valid service. Okay. He said none appears despite valid service. On respondent 1. List tomorrow.
Tomorrow, your lordship is going to hear high funded cases. May I
Not
pray that?
tomorrow. That is on 8th May.
25th. Then let there be a
Tomorrow 166.
100. So let there be a separate list.
Yes,
and
yes.
after exhaustion of our normal cases,
Correct.
then regular list that will be taken up.
Correct.
That is better. Maybe.
But it will only take 5 minutes.
Oh, thanks.
Only for this 10 hours, it will be a lot of work. Are there two variety of matters?
Two varieties. Two varieties. One variety may be urgent because one matter is before the Honorable Apex Court that has been fixed after that. In that case, that old pension matter, that in one case, Honorable Supreme Court has granted a stay and has been fixed after 4 weeks. So that batch may go, may be urgent. But so far as DLR, this is single day dispute, it can be disposed of.
So how do you know which matters are?
We'll prepare a list.
So there'll be 2 sub lists.
All
right.
We'll call the passed over. Item 32, passed over matter.
I had filed a memo for withdrawal.
All right. Memo taken on record, disposed of. Right.
Item 96.
96.
Despite a Passover, none appears for the petitioner. Copy of the writ petition has also not been served on the state. Defects have also not been cured. In the interest of justice, we list on 5th July.
5th July.
Defects be cured and copy of the petition also be served and state by them. Right. Over. All right.
Weekly list fresh admission item number 1, CRLMC 181 of 2020.
One appears.
Item number 2.
That's 2 permitted to withdraw, Your Lordship.
Dismissed as withdraw.
Item number 3.
None appears dismissed.
Item number 4.
None appears dismissed.
Item number 5.
May I please, Your Lordship, my Lord, on behalf of Mr. Rajiv Lochan Patnaik, item 5 and 11 permitted to withdraw.
All right. Memo taken on record.
Obliged, my Lord.
Item number 6.
None appears dismissed.
Item number 7.
In this case, I have filed one additional affidavit along with annexures, which has not been tagged into record. That may come next week with tagging with the additional affidavit and annexures.
When did you file it?
My Lord?
When did you file it, sir?
Yes, well, that is filed. Affidavit filed by today.
Have you already filed it? You're going to file it?
Yes, no, my Lord. It is already filed.
When did you file it?
Today filed.
Where you have a copy?
Yes, madam.
Shows. Say, departmental inquiry has nothing to do with criminal case, sir. Complete misconstruction. We're supposed to have 300 CRPC and all that.
So for this
Criminal
case
case is very different from departmental inquiries.
No, my lord. Two inquiries are there.
Whatever,
by the
that you
department.
can point out. to
One
the
is revenue
concerned
and
court,
disaster
sir.
management and another
You
child.
point out to the concerned court, if an additional affidavit has been tendered, incorrectly contending that since in two departmental inquiries, the petitioner has been exonerated, continuation of the criminal case would amount to violation of Article 20, bracket 2 of the Constitution of India and Section 300 CRPC. This submission is totally misconceived. Paragraph. Nevertheless, the petitioner is permitted to urge all the pleas available to him in accordance with law at the appropriate stage in the trial court. The petition is disposed of.
Item number 8.
None appears dismissed.
Item number 9.
None appears dismissed.
Item number 10.
I may pardon, my lord, the petitioner has taken my consent, my lord.
All right. None appears for the petitioner. Dismissed for non-prosecution.
Item number 12.
None appears dismissed.
Item number 13.
May I please, Lord, sir? May I permit to withdraw?
Dismiss is withdrawn.
Obliged.
Item number 14.
None appears dismissed.
Item number 15.
Pass over, my lord.
All right.
Item 16.
None appears dismissed.
Item number 17.
May I please, my lord? I pray that in similar cases, the petitioner has been given the order. I have given the order in another case, man. The challenge is under NBW, and in this case, the other bench has allowed me to.
All right. The petitioner will appear before
Yes,
the trial court
Yes, ma'am.
on 1st May 2023. Not 1st May, say 15th May 2023.
Ma'am.
And thereafter, pray for appropriate orders
Ma'am.
in the trial court. No further directions are called for. Till then, the NBW will not be given it. The
Obliged.
petition is dismissed.
Item number 18.
None appears dismissed.
Item 19.
Same order.
Item number 20.
Same order.
21.
Same order.
Item 22.
Same order.
Item number 23.
Same order.
Item number 24.
Same order.
Item 25.
Same order.
Item number 26.
Same order.
Item number 27.
Same order.
Item 28.
Memo taken on record. No instructions dismissed.
Item number 29.
29, my lord, sanction is involved. We'll take these points in the course of trial.
All right. Permitting the petitioner to rehearse all pleas in the appropriate stage. All right.
Item number 30.
No instruction. No instructions dismissed.
31.
May I please, Lordship? We filed the present application to quash the enter JR case, my lord, on the ground of compromise, my lord. My lord, I have stated.
You are for the opposite party number 2. All right. Counsel for the opposite party number 2 confirms that the disputes have been settled between the parties. That view of the matter. Take for the prayer clause. What's the connected matter?
Two accused persons, my lord. Two separate.
The affidavit is also taken on record. Then second matter also the same thing. All right.
W.
Item 32.
None appears dismissed.
Item number 33.
Same order.
Item 34.
Same order.
Item number 35.
Same order.
Item number 36.
Lordship, I am from BC, my lord.
Yes.
Lordship, the alleged dispute in civil in nature and in pursuant to the same, the petitioner being the accused before the learned court below has failed to pass for the same, my lord. The alleged dispute is purely civil in nature, which is occurred in between two friends. So far as the case of the prosecution is concerned, he has taken some friend loan and he did not refund, and in pursuant to the same, the father of the petitioner has executed an undertaking with the informant, which could not be fulfilled later on, for which this case was instituted against the present petitioner, my lord.
Yes.
And so on bare perusal of the case record, it clearly transpires that it's a purely civil in nature and the money could be recovered through a money suit. But though there was no deception at the very instance, and there was no malafide intention on behalf of the petitioner from the very beginning, but the case was instituted under section 420 of IPC, my lord. No.
It's all right, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Same 37 is also same.
37?
No, my lord. 37 already become infructuous, my lord.
All right. Disposed of his infractions. All right.
Item 38.
None appears dismissed.
Item number 39.
None appears dismissed.
Item 40.
Same order.
41.
Same order.
Item number 42.
Same order.
Item number 43.
43 permitted the petitioner to raise the point of plea of alibi before the learned court below.
All right. Permitting the petition.
Item 44.
44, Lordship, the nomenclature is wrong. So we will file the consolidated.
What is the matter about?
Lordship, it is a noting that the nomenclature should be CRLMA.
The petitioner seeks leave to withdraw the present petition to file a proper petition in accordance with law. Disposed of his withdrawn with liberty is prayed for. All right.
Okay.
Item 45.
None appears dismissed.
46.
So liberty may be granted to raise all the pleas.
All right. Permitting the petition.
Item 47.
None appears dismissed.
Item 48.
None appears dismissed.
49.
Same order.
Item number 50.
50 mile, there is no instruction from the side. I would like to withdraw and liberty may be granted. If
No
cause of
liberty.
action survives,
No
I'll file the petition.
No
again.
liberty and all. There's no instructions dismissed. All right.
Item 51.
None appears dismissed.
Item number 52.
My lord, 52, no instruction.
No instructions dismissed.
Item 53.
May I please, your lordship? Lordship, I have challenged the initiation of proceeding against petitioners, my lord. Lordship, may kindly see page number 19. This is a deed of settlement between the parties, my lord. In the learned court below, the opposite party number 2 has undertaken to withdraw the criminal cases instituted against the petitioner, my lord. Lordship, may see page number 19, subclause 3, my lord.
Yes.
The defendant wife shall take all effective measures to withdraw the GR case number 2814 of 2019, which was registered as per her FIR against the plaintiff and his members alleging dowry torture on her.
But the problem is that addressee is left.
Yes, my lord.
So unless you serve her, problem, sir. So better go back to the trial court. You say permitting the petitioner to raise all pleas at the appropriate stage.
Grateful.
Yes.
Item 54.
My lord, in this case, this copy for AGI has already been filed, and the notice issued to the opposite party number 2 has been returned answered. So I may allowed to permitted to take fresh steps against.
No. Permit you to raise all pleas at the appropriate stage. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right.
Item number 55.
It covered by lordship solved by giving the copy of the attorney. Here also please. Without company being may accused the
correct. But same company.
No, not same company, another company.
All right. You see,
offense is same.
See, the petitioner has been arraigned as an accused in his capacity as the manager of Mrs. Vedanta Limited, without Mrs. Vedanta Limited itself being arraigned as an accused. Then para 2, you say same thing, except that case number will change. There's no seal cover now. So only para 2 and then.
Deeply pleasure. Item 56.
56, my lord, it is noting that there is neither ready nor unserved notice has been returned back. Maybe the notice may be issued again.
No, what's the matter about?
Matter about the questioning of proceeding that's under section 145 of CRPC. It is purely civil nature because both of them are claiming title over both of land. So maybe I may be permitted to send the notice again because it is noting in the noting it is there that neither ready nor unserved notice back.
It's okay, ma'am. Permitting the petitioner to raise all pleas with the appropriate. 145 should be no problem at all.
My lord, for
actually, by passage of time, this would have become infractuous by now.
Yes. Maybe permitted to serve the notice again.
No.
Adjourn it for a short period. Because, my lord, see that section 145 of CRPC, not a single condition is matched over there. 144 proceeding also dropped because it is purely civil.
This 145 is not to be for an order for all times to come. The whole very nature of the
short adjournment. I'm just seeking short adjournment.
No, the status quo has been asked to be maintained. That status quo must be continuing.
I just want to send the notice again.
No, for what? There's no need for that.
Because it is noting there, neither ready nor unserved notice has been sent back again, returned back.
Yes.
So maybe I may be permitted to adjourn for a short period.
No.
Notice may be sent again.
The challenge in the present petition is to order passed by the learned Additional Deputy Commissioner of Police cum Executive Magistrate Bhubaneswar in CMC number 1636 of 2019 under section 145 CRPC. Requiring the parties to maintain status quo. This is only an interim order. This is only the nature of the interim order. Full stop. There's no need to, given the nature of the very proceedings, there is no need for this court to interfere at this stage. Leaving it open to the petitioner to raise all pleas at the appropriate stage. Petition is disposed of. The interim order is okay.
Item number 57.
None appears dismissed.
Item 58.
Same order.
Item 59.
Same order.
Item number 60.
Item 60, my lord, I'm appearing through VC, my lord.
Yes.
My lord, this is a matter under 100, matter challenging the initiation of proceeding by the learned executive magistrate under section 107 of CRPC without satisfying the contents of the petition without satisfying as to whether there was a necessity of initiating the proceeding. And he has directed me to execute a interim bond in the meantime, my lord.
So there's no stay passed in this matter. So you must have complied with the...
My lord, there was a stay order passed, my lord.
When?
My lord, 3/3/2020, my lord.
1 minute.
My lord, while staying the further proceedings, my lord, this honorable court had directed notice to be issued to the opposite parties, my lord. Opposite party number 2, my lord. And in the noting, my lord, indicates that the notice has neither the AD has come back nor the unserved notice has come back, my lord.
See,
my lord, it is a settled position of law that the magistrate cannot initiate a proceeding, my lord, if there is no if he has to conduct an inquiry himself before proceeding to initiate such proceedings, my lord. There are several decisions of the Honorable Supreme Court as well as this High Court, my lord. My lord, may permit me to place the decisions, my lord, the citations, my lord.
No, 1 minute. You were to serve a copy of the estate. What happened?
My lord,
what's your position? What are your instructions?
My lord, the LCR has also not been received.
Lord, LCR has not been received. That too, the order was also communicated, but nothing has been received. No instruction has been received.
Without following the procedure as enumerated under section 111 to 116 of the CRPC, my lord, he has proceeded to direct me to execute an interim bond, my lord. This is squarely covered under the judgment of my lord Madhulimai and others versus subdivisional magistrate and others, my lord. And also by several decisions of this honorable court, my lord, as reported in 99 2 OLR 123, 2009 1 OLR 935, 2004 1 OLR 20, and my lord 1991 2 OLR 75. My lord,
Just between neighbors, it seems to be some throwing of garbage, that kind of a thing.
my lord, exactly, my lord. My lord, without conducting an inquiry himself, as enumerated under section 111 to 116, my lord, he has proceeded to, while directing me to file objection, he has proceeded to direct me to file to execute an interim bond, my lord, which he cannot do, my lord, without satisfying himself first that whether there is a reason to initiate the proceeding itself. And my lord, as it is evident, my lord, from Annexure 2, my lord. My lord, there was a police report called for in that matter, but before it was received, he has directed me to execute a bond, my lord.
So Counsel for the State states that he's still awaiting instructions. The service report of, you say report of service of notice on respondent 2 is also awaited. Paragraph. Fresh notice to respondent 2 returnable on 14th August. The reminder be sent to the executive magistrate to send the record of the case for the next day. List for the roster bench.
Interim order to continue.
Interim order to continue.
Highly obliged.
Item 61. 61.
None appears dismissed.
Item 62.
None appears dismissed.
Item number 63.
May I please, Your Lordship? I am covered by this Honorable Court's judgment in this case. And previously, it's pertinent to mention that it was directed to produce an up-to-date case diary, including the CDR before next date, because of the fact that this crime is associated with a phone call. My lord will kindly see the FIR. It's a very simple FIR that the petitioner is alleged to have called the informant and have grievously caused hurt by punching him and pushing him. That is the only FIR. And my lord will kindly see that if this ingredient of section 323 is just involuntarily made out, then the High Court has the power to quash. My lord will kindly see the judgment. Just one paragraph.
Yes.
One paragraph.
No, who's appearing for the complainant? Informant is not there. You've not even made a party, please. Informant is not even made a party. You say permitting the petitioner to raise all pleas at the appropriate stage. The petition is discussed.
Obliged.
Item 64.
May I please, Your Lordship? Your Lordship, on the last occasion, it was a 1cc case on the implicated of party IR number 1217 of 2020, Your Lordship. Kindly be opposite party number 2 should be added, Sandeep Kumar Mahanti. It is the check bounce case, Your Lordship. 482 is filed under section 311, cross-examination of the witnesses. Even if no witnesses has been cross-examined, the check signature as well as the agreement signature is different. So it was the pre-COVID stage, it was filed. That's why not party of the Mr. Sandeep Mahanti, who is the complainant in the lower court, lower judiciary, Your Lordship. Kindly have a...
There's no stay of the proceedings, sir. By now the matter will be over.
My lord, my humble submission is here that, so there is one check is executed not 6/1, and another check, agreement is there. In check signature and agreement signature is different. No one examination, even if no one examination is cross-examined.
Which page is the impugned order? Page 7.
May I please, Your Lordship?
The impugned order dated 16th March 2019 passed by the SDGM bracket S cutter in 1cc case number.
My lord, now it is court of JMFC LR. It was not in SDGM. In the court of JMFC LR cutter.
Okay. Now JMFC LR cutter. But the order was passed by the SDGM, sir.
It was earlierly passed, but that file is now.
That is different. When the order was passed, it was the SDGM only who passed. I'm only dictating who passed the order.
Oblige, your lordship.
Notes the reasons for rejecting the prayer of the petitioner for recall of the witnesses for the complainant in the case under section 138 of the Negotiable Instruments Act for cross-examination. Stop. This court has heard the submissions of learned counsel petitioner and also perused the impugned order. Stop. It appears that the accused has been repeatedly found absent whenever the witnesses for the complainant were present for cross-examination. Bailable warrant had to be issued, and on 24th March 2018, the accused was released on bail on his surrender. So on the same day, he filed the petition under section 311 CRPC. But on the subsequent 3 dates, he again prayed for adjournment. Full stop. On 7 July 2018, again, the accused remained absent. Full stop. Paragraph. In the circumstances, the court is absolutely not able to find any error having been committed by the trial court in passing the impugned order dated 16 March 2019. There is no merit in the present petition. It is dismissed as such. A copy of this order be sent to the court of the JMFC LR Katak, before whom 1cc number 776 of 2016 is stated to be pending.
Item number 65.
May I please, your lordship?
May I please, your lordship, my lord? My lord, once 83 years old lady, my lord, was beaten by his son, daughter-in-law, and grandson and granddaughter, my lord, for which she lodged on FIR, my lord. FIR lodged under section 307 and all other sections, my lord. The police investigate the matter, and thereafter he filed the final form excluding the accused number 4 and 5's name, my lord. My lord, that GR case is pending in the lower court, my lord. In that case, my lord, I wanted to file one petition, my lord, which is annexure 5, my lord. But that petition could not be filed because the PP did not want to identify the informant, my lord, which is the procedure, my lord. My lord, kindly see, my lord, the FIR, my lord, it is clearly stated that she was beaten by iron rod and cautery by the accused persons, my lord. So I want only, my lord.
What has happened in the matter?
My lord.
This has been pending since 2020.
My lord. My lord, though I have filed several memos and also I have filed...
No, what has happened in the matter in the lower court?
My lord, this is pending, my lord. That GR case
At what stage? What stage is pending?
Only pending, my lord, but nothing, no evidence has been taken up and nothing else.
No, so if you, depending on what the court finds, it can frame a charge for a higher offense also. You lead evidence, you get into the box. You get into the box, lead evidence. The court can even at any stage find that offense for a graver offense is made out.
My lord, 1 minute, my lord. My lord, I may be permitted to file another petition, my lord, for change the investigating officer or by to investigate another by another SI, my lord. My lord, my lord, because that previous petition could not be filed because, my lord, this annexure 5, my lord, that previous petition could not be filed because the PP did not identify the informant, my lord.
My lord, for which I have clearly stated that the accused persons were they attacked me in iron rod and other, my lord. My lord, the IO, my lord, the investigating officer, my lord, excluded the name of the accused person, accused number 4 and 5, my lord.
It's okay, madam. So whatever emerges in the trial court, they can always summon additional accused.
My lord,
there are enough provisions in the CRPC.
My lord, that liberty may be given, my lord.
CRPC is there. It gives you the liberty. We don't have to give you the liberty.
My lord,
there are enough provisions in the CRPC for all this.
I only want, my lord, that investigation may be done by another IO because the final
this is not that kind of a case.
My lord, because my lord, in the charge sheet, my lord, the investigating officer, though it is made out a case of 307, he has made out a case of only 354 and other things, my lord. My lord, I'm that old lady, my lord, 83 years old lady, my lord.
Right.
What can she do, my lord?
Yes.
My lord,
you can advise her properly using the CRPC.
My lord, I only beg, my lord.
Yes.
A petition may be filed by us, my lord. That liberty may be given.
There's no need for liberty, madam. There are enough provisions in the CRPC.
So, my lord, that may be
permitting the petition to all the
I may be permitted to
other appropriate remedies that are available to her in accordance with law. The petition is disposed of. Right.
Item 66.
May please, your lordship. My lord, raise all the point learned court below.
Yeah, permitting the petitioner to raise.
Yes.
Item 67.
Your Honor, I am appearing for the opposite party.
All right. None appears to the petitioner. This person was asked.
Item 68.
My lord, 68 compromise on the passing of the proceeding on the basis of compromise. My lord, affidavit has been filed at part B.
Counsel for opposite party number 2.
I am opposite party.
Confirms the affidavit filed by her client, confirming that which states that the parties have settled their disputes and that she has no objection to the prayer in the present petition being allowed. Accordingly, take from the prayer clause and all proceedings consequent thereto are hereby quashed.
Item 69.
None appears dismissed.
Item number 70.
None appears dismissed.
71.
Same order.
Item 72.
72, my lord, liberty may be granted to raise all the points during trial.
All right. Permitting the petition.
I'm from the opposite party.
All right.
Item 73.
73, my lord, on the basis of compromise, I filed this petition. A friend is appearing, my lord.
All right. Opposite party number 2 confirms that the parties have settled their disputes and that the copy of the compromise affidavit is at Annexure 2 in that view of the matter. Take from the prayer clause and all proceedings consequent thereto are hereby.
Obliged, deeply obliged.
Item 74.
None appears dismissed.
Item number 75.
None appears dismissed. All right. She's for the opposite side. All right.
75.
None appears dismissed.
Item number 76.
Lordship, I am on behalf of the petitioner, and in the meantime, the alleged dispute has already been settled before the learned court below, my lord. The opposite part 2 has already
This is
entered.
infructuous. All right.
Item 77.
Lordship, just not audible, Lordship. Sorry, my lord.
Disposed of as infructuous, sir.
77, may I please, Lordship. This is an application against an order passed by the London SDJ Madgaon in rejecting an application under section 205 filed by the petitioner of the CRPC, your Lordship. My respect, Lordship, may kindly dispose of dispensing the personal appearance accused and face the trial, your Lordship. Here is the case. His petitioner is government servant and also being a lady.
It's all right. Counsel, the petitioner will appear before the trial court on 15th, 2023.
Sorry, my lord. I beg your pardon, my lord. Item number 76. It's a marital dispute, my lord. In the mutual divorce has been granted, and before the learned court below, that is the family court, they have entered into the compromise. But the criminal case is still pending, my lord. That was my submission. The opposite party number 2, being the wife of the petitioner number 1, has entered her appearance before the honorable court, my lord. That was my submission. That it was disposed of before the family court, but the criminal case is still pending, my lord.
Who's appearing for the other side?
Though he has entered his appearance, but he is not here, my lord.
Why don't you
Lordship,
point out
may
in the trial court itself? Then you can point this out in the trial court itself. You say
Lordship,
the petitioner contends that the matters have already been, divorce has already been granted. Because you have not even produced a divorce decree, sir.
No, my lord. That is why I am praying that it was granted recently, and so I may be granted a liberty to place those documents and the matter may be listed.
Permitting the petitioner to place all the documents before the trial court and to seek appropriate orders, the present petition is disposed of. All right.
Item 77.
May I please, here is the against an order passed by the
The petitioner will appear before the trial court on 15th May and then pray for appropriate directions. Till then, the interim order will continue.
So discipline the personal appearance by executing and undertaking lots of agent when the trial court is directed, the petitioner
determines that the trial court will determine. All right.
Item number 78.
A copy of this order will be sent to the trial court. None appears dismissed.
Item number 79.
May I please before your lordship? My lord, the 13B mutual divorce has already been annexed to page 13, my lord. And annexure 1 is the FIR in 498A, 323 and 34 4 DP Act has been registered. Already informant is added and opposite party number 2 and postal tracking report with endorsement is sufficient and order number 4.
Despite service, none appears for the opposite party number 2. The petitioner has annexed to copy of the judgment passed by the Family Court Bhubaneswar in civil proceeding number 397 of 2019, dissolving the marriage between the petitioner and opposite party number 2 under section 13 capital B of the Hindu Marriage Act 1955. In that view of the matter, take from the prayer clause and all proceedings consequent thereto hereby quashed.
Item number 80.
None appears dismissed.
One passed. Passed over matter item number 15.
And the file last version of file I on 1353 of 2021 to added the opposite accused person as opposite party number 2. 1353.
All right. What's the matter about?
Matter is also file the complainant filed a petition under section 202, which has rejected 302 CRPC, which has rejected to appointed a special private counsel in respect of government counsel as case and counter case, my lord.
No, what's the need for a special counsel? What is the matter about?
Matter which case and counter case, my lord, in para 2. That
but 420 and all, why do you need special counsel, sir? This is not that kind of a matter.
Because case and counter case and one government counsel was conducting this case, for which the complainant apprehending the case may be he will suffer as the government counsel conducting case from another side.
By now, it will not change, sir. The government panel counsel keeps changing.
So he may allow to, in this case, to help the government counsel appointed in one's case.
There is no compelling reasons. I tend to agree. You say the counsel is, the petitioner is aggrieved by an order dated 5th November 2019, passed by the JMFC Jashpur Road in GR number 624 of 2016, declining the prayer to appoint a special counsel, special prosecutor under section 302 CRPC. Full stop. The Perus, having heard learned counsel, this court has heard learned counsel for the petitioner and has also perused the impugned order passed by the trial court. Full stop. The trial court has come to the conclusion that there are no compelling and cogent reasons to accede to the prayer of the petitioner. Stop. The APP is already been appointed and is appearing the case. It is a case under section 420, 403, 468, 294, 506 IPC. Full stop, and charge has already been framed and the case is at the stage of hearing. Even in this court, there was no stay granted of the proceedings in the trial court. In that view of the matter, the court sees no reason why it should interfere at this stage. Indeed, there are no compelling reasons to accede to the prayer of the petition. The petition is accordingly dismissed.